Release the body slam footage. Come on and slam. And welcome to the jam. REKIETA house is ruined. So REKIETA update, last 3 weeks. So not much has happened really in the last 3 weeks. The body cam footage being delayed was one thing. Immediately after that, Oliver Bromka, who is a elected attorney, I'm not sure if he's elected in Minnesota or North Dakota, but he's a registered licensed attorney on the bar for both Minnesota and North Dakota. And he is Hardin's lawyer. Hardin represents our interests, but for various reasons, you never want to be your own lawyer, even as a lawyer. So he's had Oliver Bromka assist him. And I'm probably saying his name wrong. I can't. It reads as Bromka, but I think he goes by Bromkey. Anyways, I'm gonna keep saying it wrong until I'm corrected. Bromka filed an intervention in Nick REKIETA's criminal case to oppose the decision to reclassify evidence that was considered as a matter of course as not received, which makes it unavailable to the public. In particular, the one thing that happened is that the judge, or sorry, not the judge, actually, yes, the judge and the prosecutor both knew that Hardin was in the process of acquiring this footage. And as I mentioned on my last stream, when the prosecutor and the judge rushed this motion through to reclassify that evidence as received but not submitted into evidence, they erred because when a motion is filed in court, it is supposed to represent all parties. And the judge and the prosecutor both knew that Hardin would oppose this. And in the instance where a non-party has an interest in something, the prosecutor is actually supposed to represent their interests and take a much more neutral and self-critical approach. Normally, when you're just having adversarial filings, you have like the plaintiff and the defendant. You're supposed to represent your case as strongly as possible. But in the instance where you have a third party that has an interest that's not a party to the case, you're supposed to be very reasonable. And you're supposed to say, well, judge, I think that this evidence should be reclassified. However, there's an unrepresented party. So you're supposed to play devil's advocate and say, so they would probably say X, Y, Z. I think that I'm in the right, but they would probably make these legal arguments. And that's supposed to create like a paper trail where down the road, if that party does intervene, their interests are actually represented. So it's a very weird legal thing where you're supposed to not be super adversarial. That did not happen. So the prosecutor just said, yeah, seal this shit up. Nobody disagrees with this decision whatsoever. So just do it right now. And the judge said, okay, fine. So the prosecutor lied. He knew that there were adversarial interests. In fact, I know that he knew that there were adversarial interests because he emailed the attorney immediately afterwards and told Hardin, yeah, we sealed this shit up. Eat shit. So he knew that there were adversarial interests and did not represent them at all, which is a bad thing to do. You're not supposed to do that. So that will form the basis of the criminal intervention because they're in the wrong to do that. So the second thing is that Hardin, behold, Matthew D. Hardin, plaintiff, versus Eric Tollinson in his official capacity as sheriff, the Kadiyohi Sheriff's Office. Carol Coleman in her official capacity as records supervisor, Kelsey Baker in her official capacity as Kadiyohi County administrator. Plaintiff Matthew D. Hardin, hereinafter plaintiff, by and through undersigned counsel, files this complaint against defendants Sheriff Eric Tollinson in his official capacity. I already read that. Pursuant to Minnesota Statute 13.08, plaintiff seeks release of improperly withheld government data under the Minnesota Government Data Practices Act, and alleges the following. So this is now filed. You can see that little thing on the top right. Minnesota Court Records Online. Received literally just now. Actually, it was received a little while ago, but it's not made public until the clerk receives it and marks it received, which just happens. So we're suing, not me, actually. I have no party in this. So if Hardin does win $1 million, as REKIETA would wish him, for this case, he keeps all of it. And that's just my luck. I have a feeling that Hardin's going to win like $1 million in punitive damages from the county for these games that they're playing. And then, of course, I may receive none of it because I have no interest in it. It was Hardin who filed the request, chat. He's going to make a milli. Yeah, that's basically what's going to happen. So this is 12 pages, and then I guess the rest is evidence. The rest, okay, so I know what the exhibits are going to be. The basis of this complaint is that Hardin went through all the appropriate legal venues to file this complaint. He went to the judge. The judge accepted his request. The judge granted him what he asked for and administratively said, you must release this footage. Then he went to the sheriff and said, Sheriff, look, you didn't release it before when we asked you nicely, but now the judge is telling you to release the footage. And the sheriff says, no, I will ignore this court order, stalker. Goodbye. So the sheriff refused to acknowledge the court order. Then he has to, another lawyer advised him to file a complaint with the Minnesota Department of Administration. And the Department of Administration gave an opinion that was affirmative and said, yeah, they should release the footage because why would he ignore a court order? Then he showed the sheriff that, and he said, okay, give me until June 2nd. And then days before June 2nd, like May 30th, like the day of the stream, the prosecuting attorney files a request to seal the footage, and then the judge agrees within 50 minutes of court opening the next day. So it was like this very calculated maneuver to seal the records that had already been granted approval to be made public, and that the Department of Administration had already agreed should be made public. So it was like this very collaborative effort, and these attachments are going to be all the steps, all the time, all the effort that it took for Hardin to go through this the correct way to get these files released and being granted the files to be released and then them changing their mind last second. So that's what that is. I haven't been able to read through it because it literally just happened and I just published it. But yeah, we are suing Kadiyohi County. And this is only prong 2 of 3. There's something else that Hardin wants to do that's very cheeky. And when he does it, it's probably going to be one of the only times that this has ever happened in litigation history. Basically, Hardin's going to tackle all 3 prongs of the justice system at once, and we're in an effort to get the body cam footage shot. Oh, we we have a constitutional right to see evidence. I remind you, here's the main thing, right? Here's the main crux of this, is that Nick REKIETA very arrogantly declared that the Kadiyohi County Sheriff's Department had violated the constitutional rights of his co-defendant April Imholt and not properly Mirandized her. Not Mirandizing a defendant is one of the most egregious violations that a police officer can do in the course of an investigation, and it completely throws out any information obtained as a result of that. If you walk up to a killer and said, "Hey, did you kill that guy?" and he says yes, and you didn't Mirandize him before, that outright confession that he somebody does not get entered into evidence. There's nothing you can do about it. It's just as good as it never happened. So, to prove this, he submitted the body cam evidence. In his own attorney submitted this into evidence, and it was considered before the omnibus hearing, and then later they didn't pursue it because the body cam evidence, as it turned out, actually showed her being Mirandized. So his contention is that because he didn't actually go for using this as evidence because it was evidence against him, that therefore he didn't actually submit it into evidence to begin with, which is a lie. Hardin's position, our position, is that it was submitted into evidence, so he has no right to complain. And then also probably, I would imagine, that he asserts other justifications, such as the rumors that REKIETA had started in regards to evidence being planted and to misconduct by the sheriff's department, by conspiracy against him, and so on and so forth. And then also confusing things like Jesse published like a bunch of AI generated fake photos of the house, and that it also led to further confusion. Oh, and statements that REKIETA had made, such as the sheriff lied in order to get his children taken away by saying that there was some dust on the vents, and therefore the dust on the vents meant his whole house was filthy. So it's like, which is it? Did the sheriff lie to get his kids taken away by saying that his house was messy and unlivable and uninhabitable because there was some dust on the vents, or was there actual trash in the house? There's a genuine public interest in knowing what was happening in the legal system. And we're going to get it, is what I'm saying. So there's that. The only other thing that happened with REKIETA was that Gabe Hoffman apparently is trying to debut as a streamer. I don't know what he's doing. He made a stream that was generally not well received. He went live with Keanu, that woman that epically owned REKIETA a couple weeks ago. And basically, he just he said that REKIETA had been physically violent towards Kayla and his kids, and the whole stream was underwhelming and poorly presented, and people were very dissatisfied with it. I'll say that. That was the consensus, the takeaway that I saw. Let's see. Introduction. Plaintiff submitted a request to defense on May 23rd, 2024, seeking a full year. We've been going on a full year now. They submitted another request. We're seeking, in particular, body cam footage, dash cam footage, cruiser video footage, and other video recordings. Remember, there's 9 actual videos that we can get if we get everything. Seek it under the Minnesota Data Act. Highly interesting and controversial arrest of a local attorney. Should be released in full, despite multiple current correspondences, as well as with a supporting opinion from the Commissioner of Administration, which is a very Soviet-sounding name. The defendants have released only a few records while denying access to others either implicitly or explicitly. Additionally, defendants have also shifted their explanations for withholding records, making it difficult or impossible for plaintiffs to intelligently challenge the defendants' continually evolving narratives. As the defendants were put on notice that the instant suit would be forthcoming, the defendants sought to correct court records in a way that would impair Mr. Hardin's substantial rights under the MGDPA without providing Mr. Hardin any opportunity to be heard or to challenge the purported correction. Against this backdrop, Mr. Hardin has no choice but to file this claim. That's what I was talking about, in that they did not represent his interests in making that request, so they just kind of like pretended that they have a right to do that. Just a summary of who the parties are. Summary of the jurisdiction. Okay, here's the request. So, on the 23rd last year, Hardin requested by correspondence records related to REKIETA, April Imholt, and Kayla. Carol Coleman responded with the one-page incident report related to possible child neglect or abuse. It has been apparent from numerous sources, including from a live stream Nick REKIETA posted on the uppercase I bold internet. Did he do that on? That's gaslighting me. Bromka in this filing embolded that I. That's a bold I. That's not a regular I, chat. That's not just a capital I. That's a bold capital I. This is gaslighting. This is designed to with me mentally, chat. The numerous additional records responsive to Mr. Hardin's May 23, 2024 request exist and are not accounted for by Carol Coleman or any other defendants. On information and belief, Mr. Hardin alleges that the additional records which exist and which Mr. Coleman failed to provide are not exempt from the production under the MGPA. So this is the email that he sent her, saying please, or that she responded to, saying that we have the request. Oh, okay. This is the email that she sent him in regards to my request, and she clarifies that you can get the records, but we have to pay that fee. I contacted our forensic staff that handles the body cam footage and received a rough estimate of what it would cost. The fee is $60 an hour and would be roughly 50 hours to go through the body cams. The fee for just the footage is $3,000, and this would need to be paid before it can be released. Due to the ongoing status of the case, we are unable to provide an exact release date for the body cam footage at the time. So we offered to pay it, and then she refused to accept the payment, and we haven't paid her, to be clear, but also indicated that she was not denying the request. She said, no, your request isn't denied. We do not accept deposits on requests. We need to wait until the investigation is complete before we start processing the footage. Hardin wrote her a week later and asked, "I would like to renew my request. My understanding is that the criminal matter has now concluded with a guilty plea." Oh, on February 10th, so this is next year, a couple months ago, Coleman responded saying, "At this time, we are still unable to release the footage as the case is still pending in court due to the involvement of co-defendants. Once the proceedings involving the co-defendant have concluded, you may submit a new request along with signed releases from all individuals captured in the footage." Hardin wrote to her, probably because that's bullshit what she's saying right there, with an order. Okay, so this is May. So this is after he got the order from the judge saying release the footage. Hardin wrote Coleman with the order from the Kadiyohi County District Court, in which the court recognized that the body camera footage is a matter of state of Minnesota versus REKIETA, was public data on individuals under the MGDPA, and was available from the original custodian. He renewed it and then offered to pay the $3,000. Coleman responds and says that the Minnesota statute chapters do not have a clause related to courtroom evidence. As such, any BWC footage from this incident would need to have written consent for release from all non-public officials in those videos. Once the consent for releases are provided, we can move forward with your request. So then we submit it to the Commissioner of Administration, asking if that's true. The Commissioner of Administration responds and says, "No, it is not true. So the advisory opinion that body cam data maintained by the law enforcement agency and presented as evidence in court is classified as public data, and that the law enforcement agency did not respond appropriately when it failed to provide access to those data upon request. Individuals who are similarly situated may rely on guidance provided in any opinion unless the Commissioner states otherwise." So then the commissioner actually called Eric Tolfson the next day and told him that he must release the footage. So now the state is calling this guy up and it's like, "What the f are you doing? Obey the court order, you idiot." So then Hardin sends a letter to the sheriff and the county attorney indicating that we would sue them unless the MGDPA obligations are met. And then with the full awareness that not only do they have to release the footage and that we are about to sue them, the attorney then afterwards submits a motion in the court in the criminal case to exclude certain evidence by marking it as not received. And then so unaware of the full circumstances behind the consent motion of the Kadiyohi County attorney and without hearing any argument from Mr. Hardin or anyone else, this court entered an order which purported to correct its records to indicate that certain evidence was not received through MNDS on the basis revoked all previously allowed public access thereto, after two interested parties had already reviewed the footage at the courthouse and a third had scheduled a viewing. This was error provoked by the county attorney who acted on behalf of the defendants to frustrate Mr. Hardin's rights under the MGDPA in a rush proceeding of which Mr. Hardin was given no advance notice. Immediately upon receiving the order correcting the records, Mr. Baker of the Kadiyohi County Attorney's Office sent a letter to Mr. Hardin denying his request for records in full. Not only was the order defendants obtained from the district court obtained by collusive efforts between a nominal plaintiff and a nominal defendant, seeking the same outcome without providing notice to the only party who would be adversely affected by the correction. The order was also in excess of the court's jurisdiction. Courts simply, quote, "do not have the power, even were we of the mind to use it if we had it, to make what has thus become public private again." That's a very complicated sentence. I'll read it again. Courts simply, quote, "do not have the power, even were we of the mind to use it if we had, to make what has thus become public private again." And that is from Gamble versus Deutsche Bank AG. And that was a very, very recent federal ruling, which cited the federal U.S. Constitution as being relevant. So this is a federal constitutional issue. So the statement, plaintiff wants the body cam footage. Plaintiff is entitled to disclosure of the requested data for several reasons. The body cam data was presented as evidence in court. Specifically, criminal defendant Nicholas REKIETA's own attorney, Francis White, submitted the body cam footage in support of a motion to dismiss filed in the state of Minnesota versus REKIETA. Additionally, Mr. White, on behalf of Mr. REKIETA, cited extensively to the footage in his briefing filed with this court. While transcripts purport that to reflect that Mr. White said words to the effect that the court could get rid of that evidence, there is no basis for the court to falsify its own records after they are received by striking entirely certain evidence from the record. No party attempted to follow the rules that apply to remove presented evidence from the Indian DES system, not least until long after those records were submitted and relied upon in a criminal defendant's briefing. Second, it has been revealed in recent days that a great body of additional responsive records exists with the defendants never acknowledged in response to Mr. Hardin. Specifically, there are warrant applications which use the word REKIETA, and there are photographs the sheriff's office took in executing a search warrant at the REKIETA residence. Despite this, the defendants never acknowledged these records existed and never provided them in response. So this is a result of REKIETA running his mouth, by the way. When the police were when he was showing photos of his house and talking about his warrants and shit, he revealed that there was more information that the sheriff's office was intentionally withholding from Hardin, not just the body cam footage, which is a exacerbating issue in our benefit, because it shows that there is a concerted effort to hide something that should not be hidden. Defendants have constructively and actually denied plaintiff access to requested records. The denials of access were willful. Moreover, they were undertaken with the express intent to circumvent Mr. Hardin's rights. Plaintiff was harmed as a result of defendants' willful violations of the MGDPA. Long after Mr. Hardin had obtained access to judicial records, which were offered as evidence, that access was suddenly revoked. Moreover, Hardin was unaware of the existence of numerous additional records which were responsive to his first request until REKIETA, one of the subject of the records, publicly posted about them online. Defendants did not even formally deny Mr. Hardin access to certain records in a way that was capable of judicial review. Instead, Ms. Coleman simply failed to acknowledge the existence of records for a period of over a year. Defendants' willful violations of the MGDPA and the disregard of an opinion of the Commissioner of Administration, especially when coupled with their efforts to end-run Mr. Hardin's request by seeking without any notice to correct records which needed no correction, entitled plaintiffs to his costs and disbursements, including reasonable fees under the statute. So the law in Minnesota is that if you talk to the Department of Administration and you get a favorable judgment, the courts must mandatorily award you any attorney's fees. So part of the reason why they went out and did everything by the number is that now that he's suing them, when he prevails, the Minnesota statute explicitly states that if the defendants are the government and the government is ignoring the Department of Administration's decisions and opinions, then mandatorily they must pay fees as well. Plaintiff is entitled to an immediate injunction preventing continuation of defendants' willful and continued violations of the MGDPA. Plaintiff realleges defendants denied requests by failing to respond lawfully. Requires the disclosure of public data on individuals, public data not on individuals, and government data. These are those kinds of records. There is no potential harm to the public that may result from the release of the footage. Even if defendants had identified such harms, they would be legally irrelevant. The Minnesota Supreme Court has made it clear that under the MGDPA, government data is presumed public unless there is federal law, a state statute, or temporary classification of data that provides that certain data is not public. No federal law is relevant here. He is entitled to the footage. Wherefore, submits and respectfully prays that this court issue a declaratory judgment that the information requested is public information within the meaning of the MGDPA and is therefore producible under that act, and that the defendants have improperly failed to produce such information. Enter a permanent injunction directing defendants to comply fully with the MGDPA and without further delay to furnish plaintiff the data. This is the important thing, chat. I need like a yellow highlighter so we know what this is. Thickness, maximum thickness. The data. Am I not going to be able to get it? Oh my God. Adobe, what are you doing, brother? I just want to highlight that to say the data. Instead of moving around the background image. Come on. Only to legally allowable withholdings justified by sufficient identification for the reasons withholding. Grant plaintiff additional injunctive release, barring defendants from continuing practices that infringe upon plaintiff's rights, including the solicitation and use of ex parte judicial action to frustrate public access and the refusal to produce clearly public records, access to a civil penalty, awarded fees, costs, disbursements, including fees, attorney's fees, order such additional relief as the court may deem just and proper. Submitted by Bromco. And this is a bunch of emails. So he's asking for, number 1, the body cam footage. Number 2, injunctive relief, ordering the sheriff to stop around and release the body cam footage. And 3, the money. That is what we're going to get, Chad. And then after, if the judge decides that he's going to deny this, which he can, he's the same judge that classified the evidence as not public anymore to begin with. It then goes to the Minnesota Court of Appeals, and then the Minnesota Supreme Court, and then, Allah forbid, the United States Supreme Court. But I have a feeling that what's going to happen is that the judge, one of two things is my prediction. A, I think it's very likely the judge will realize that nobody's playing games. We want the body cam footage, and we are going to get it. And then the second likely thing that's going to happen, if that doesn't happen, is once this escapes the county of Kadiyohi and goes up to the appeals court is going to be like, what the are you doing? Release the body cam footage. And then we'll get it. But that's what's happening. Over a bet? No. It is about my constitutional right to know how my justice system works. That's how it works, Jeff. That's what it's about. Never give up your rights. You have to fight tooth and nail for your rights. If you want to have rights, you have to fight for them.